Criminal Justice Brief. Glossary. Comprehensive Criminal Justice Terminology. A. 1983 Lawsuit. A civil suit brought under Title 42, Section 1983, of the U.S. Code against anyone who denies others their constitutional right to life, liberty, or property without due process of law. Abused child. A child who has been physically, sexually, or mentally abused. Most states also consider a child who is forced into delinquent activity by a parent or guardian to be abused. Actus reus. An act in violation of the law. Also, a guilty act. Adjudicatory hearing. The fact-finding process wherein the juvenile court determines whether there is sufficient evidence to sustain the allegations in a petition. ADMAX. Administrative maximum. This term is used by the federal government to denote ultra-high security prisons. Administration of justice. The performance of any of the following activities: detection, apprehension, detention, pretrial release, post-trial release, prosecution, adjudication, correctional supervision, or rehabilitation of accused persons or criminal offenders. Adversarial system. The two-sided structure under which American criminal trial courts operate that pits the prosecution against the defense. In theory, justice is done when the most effective adversary is able to convince the judge or jury that his or her perspective on the case is the correct one. Aggravated assault, UCR. The unlawful, intentional inflicting, or attempted or threatened inflicting, of serious injury upon the person of another. While aggravated assault and simple assault are standard terms for reporting purposes, most state penal codes use labels like first degree and second degree to make such distinctions. Aggravating circumstances. Circumstances relating to the commission of a crime that make it more grave than the average instance of that type of crime. Alibi. A statement or contention by an individual charged with a crime that he or she was so distant when the crime was committed, or so engaged in other provable activities, that his or her participation in the commission of that crime was impossible. Alter ego rule. In some jurisdictions, a rule of law that holds that a person can only defend a third party under circumstances and only to the degree that the third party could act on his or her own behalf. Alternative sentencing. The use of court-ordered community service, home detention, day reporting, drug treatment, psychological counseling, victim offender programming, or intensive supervision in lieu of other, more traditional sanctions, such as imprisonment and fines. Anticipatory warrant. A search warrant issued on the basis of probable cause to believe that evidence of a crime, while not currently at the place described, will likely be there when the warrant is executed. Appeal. Generally, the request that a court with appellate jurisdiction review the judgment, decision, or order of a lower court and set it aside, reverse it, or modify it. Appellate jurisdiction. The lawful authority of a court to review a decision made by a lower court. Arraignment. Strictly, the hearing before a court having jurisdiction in a criminal case, in which the identity of the defendant is established, the defendant is informed of the charge and of his or her rights, and the defendant is required to enter a plea. Also, in some usages, any appearance in criminal court prior to trial. Arrest. The act of taking an adult or juvenile into physical custody by authority of law for the purpose of charging the person with a criminal offense, a delinquent act, or a status offense, terminating with the recording of a specific offense. Technically, an arrest occurs whenever a law enforcement officer curtails a person's freedom to leave. Arson, UCR. The burning or attempted burning of property, with or without the intent to defraud. Some instances of arson result from malicious mischief, some involve attempts to claim insurance monies, and some are committed in an effort to disguise other crimes, such as murder, burglary, or larceny. Assault, UCR. An unlawful attack by one person upon another. Historically, assault meant only the attempt to inflict injury on another person. A completed act constituted the separate offense of battery. Under modern statistical usage, however, attempted and completed acts are grouped together under the generic term assault. Attendant circumstances. The facts surrounding an event. B. Bail. The money or property pledged to the court or actually deposited with the court to effect the release of a person from legal custody. Bail bond. A document guaranteeing the appearance of a defendant in court as required and recording the pledge of money or property to be paid to the court if he or she does not appear, which is signed by the person to be released and anyone else acting in his or her behalf. Bailiff. The court officer whose duties are to keep order in the courtroom, to secure witnesses, and to maintain physical custody of the jury. Balancing test. A principle, developed by the courts and applied to the corrections arena by Pell v. Procania, that attempts to weigh the rights of an individual, as guaranteed by the Constitution, against the authority of states to make laws or to otherwise restrict a person's freedom in order to protect the state's interests and its citizens. Bill of Rights. The popular name given to the first 10 amendments to the U.S. Constitution, which are considered especially important in the processing of criminal defendants. Biological weapon. A biological agent used to threaten human life, for example, anthrax, smallpox, or any infectious disease. Bivens action. A civil suit, based on the case of Bivens v. 6 unknown federal agents, brought against federal government officials for denying the constitutional rights of others. Blended sentence. A juvenile court disposition that imposes both a juvenile sanction and an adult criminal sentence on an adjudicated delinquent. The adult sentence is suspended on the condition that the juvenile offender successfully complete the term of the juvenile disposition and refrain from committing any new offense. Booking. A law enforcement or correctional administrative process officially recording an entry into detention after arrest and identifying the person, the place, the time, the reason for the arrest, and the arresting authority. Bureau of Justice Statistics, BJS. A U.S. Department of Justice agency responsible for the collection of criminal justice data, including the annual National Crime Victimization Survey. Burglary, UCR. The unlawful entry of a structure to commit a felony or a theft, excludes tents, trailers, and other mobile units used for recreational purposes. For the UCR, the crime of burglary can be reported if an unlawful entry of an unlocked structure has occurred, a breaking and entering of a secured structure has taken place, or a burglary has been attempted. C. Capital offense. A criminal offense punishable by death. Capital punishment. The death penalty. Capital punishment is the most extreme of all sentencing options. Case law. The body of judicial precedent, historically built on legal reasoning and past interpretations of statutory laws, that serves as a guide to decision-making, especially in the courts. Caseload. The number of probation or parole clients assigned to one probation or parole officer for supervision. Chain of command. The unbroken line of authority that extends through all levels of an organization, from the highest to the lowest. Change of venue. The movement of a trial or lawsuit from one jurisdiction to another or from one location to another within the same jurisdiction. A change of venue may be made in a criminal case to ensure that the defendant receives a fair trial. Circumstantial evidence. Evidence that requires interpretation or that requires a judge or jury to reach a conclusion based on what the evidence indicates. From the close proximity of the defendant to a smoking gun, for example, the jury might conclude that she pulled the trigger. Civil death. The legal status of prisoners in some jurisdictions who are denied the opportunity to vote, hold public office, marry, or enter into contracts by virtue of their status as incarcerated felons. While civil death is primarily of historical interest, some jurisdictions still limit the contractual opportunities available to inmates. Civil justice. The civil law, the law of civil procedure, and the array of procedures and activities having to do with private rights and remedies sought by civil action. Civil justice cannot be separated from social justice because the kind of justice enacted in our nation's civil courts is a reflection of basic American understandings of right and wrong. Civil law. The branch of modern law that governs relationships between parties. Civil liability. Potential responsibility for payment of damages or other court-ordered enforcement as a result of a ruling in a lawsuit. Civil liability is not the same as criminal liability, which means open to punishment for a crime. Classification system. A system used by prison administrators to assign inmates to custody levels based on offense history, assessed dangerousness, perceived risk of escape, and other factors. Clearance rate. A traditional measure of investigative effectiveness that compares the number of crimes reported or discovered to the number of crimes solved through arrest or other means, such as the death of the suspect. Closing argument. An oral summation of a case presented to a judge, or to a judge and jury, by the prosecution or by the defense in a criminal trial. Common law. Law originating from usage and custom rather than from written statutes. The term refers to an unwritten body of judicial opinion, originally developed by English courts, that is based on non-statutory customs, traditions, and precedents that help guide judicial decision-making. Community corrections. The use of a variety of officially ordered program-based sanctions that permit convicted offenders to remain in the community under conditional supervision as an alternative to an active prison sentence. Community court. A low-level court that focuses on quality-of-life crimes that erode a neighborhood's morale, that emphasizes problem-solving rather than punishment, and that builds on restorative principles such as community service and restitution. Community policing. A collaborative effort between the police and the community that identifies problems of crime and disorder and involves all elements of the community in the search for solutions to these problems. Community service. A sentencing alternative that requires offenders to spend at least part of their time working for a community agency. Compelling interest. A legal concept that provides a basis for suspicionless searches when public safety is at issue. Urinalysis tests of train engineers are an example. It is the concept on which the U.S. Supreme Court cases of Skinner v. Railway Labor Executives Association and National Treasury Employees Union v. Von Rapp turned. In those cases, the court held that public safety may sometimes provide a sufficiently compelling interest to justify limiting an individual's right to privacy. Competent to stand trial. A finding by a court, when the defendant's sanity at the time of trial is at issue, that the defendant has sufficient present ability to consult with his or her attorney with a reasonable degree of rational understanding and that the defendant has a rational as well as factual understanding of the proceedings against him or her. CompStat. A crime analysis and police management process built on crime mapping that was developed by the New York City Police Department in the mid-1990s. Computer crime. Any crime perpetrated through the use of computer technology. Also, any violation of a federal or state computer crime statute. Also called cybercrime. Computer virus. A computer program designed to secretly invade systems and either modify the way in which they operate or alter the information they store. Viruses are destructive software programs that may effectively vandalize computers of all types and sizes. Concurrence. The coexistence of an act in violation of the law and a culpable mental state. Concurrent sentence. One of two or more sentences imposed at the same time, after conviction for more than one offense, and served at the same time. Also, a new sentence for a new conviction, imposed upon a person already under sentence for a previous offense, served at the same time as the previous sentence. Conditional release. The release of an inmate from prison to community supervision with a set of conditions for remaining on parole. If a condition is violated, the individual can be returned to prison or face another sanction in the community. Conditions of parole, probation. The general and special limits imposed on an offender who is released on parole, or probation. General conditions tend to be fixed by state statute, whereas special conditions are mandated by the sentencing authority, court or board, and take into consideration the background of the offender and the circumstances of the offense. Conflict model. A criminal justice perspective that assumes that the system's components function primarily to serve their own interests. According to this theoretical framework, justice is more a product of conflicts among agencies within the system than it is the result of cooperation among component agencies. Consecutive sentence. One of two or more sentences imposed at the same time, after conviction for more than one offense, and served in sequence with the other sentence. Also, a new sentence for a new conviction, imposed upon a person already under sentence for a previous offense, which is added to the previous sentence, thus increasing the maximum time the offender may be confined or under supervision. Consensus model. A criminal justice perspective that assumes that the system's components work together harmoniously to achieve the social product we call justice. Corporate crime. A violation of a criminal statute by a corporate entity or by its executives, employees, or agents acting on behalf of and for the benefit of the corporation, partnership, or other form of business entity. Corpus delicti. The facts that show that a crime has occurred. The term literally means the body of the crime. Court of last resort. The court authorized by law to hear the final appeal on a matter. Courtroom work group. The professional courtroom actors, including judges, prosecuting attorneys, defense attorneys, public defenders, and others who earn a living serving the court. Crime. Conduct in violation of the criminal laws of a state, the federal government, or a local jurisdiction, for which there is no legally acceptable justification or excuse. Crime control model. A criminal justice perspective that emphasizes the efficient arrest and conviction of criminal offenders. Crime index. An inclusive measure of the violent and property crime categories, or Part I offenses, of the Uniform Crime Reports. The crime index has been a useful tool for geographic, state-to-state, and historical, year-to-year, comparisons because it employs the concept of a crime rate, the number of crimes per unit of population. However, the addition of arson as an 8th index offense and the new requirements with regard to the gathering of hate crime statistics could result in new crime index measurements that provide less than ideal comparisons. Crime prevention. The anticipation, recognition, and appraisal of a crime risk and the initiation of action to eliminate or reduce it. Crime typology. A classification of crimes along a particular dimension, such as legal categories, offender motivation, victim behavior, or the characteristics of individual offenders. Criminal intelligence. Information compiled, analyzed, and/or disseminated in an effort to anticipate, prevent, or monitor criminal activity. Criminal justice. In the strictest sense, the criminal, penal, law, the law of criminal procedure, and the array of procedures and activities having to do with the enforcement of this body of law. Criminal justice cannot be separated from social justice because the kind of justice enacted in our nation's criminal courts is a reflection of basic American understandings of right and wrong. Criminal justice system. The aggregate of all operating and administrative or technical support agencies that perform criminal justice functions. The basic divisions of the operational aspects of criminal justice are law enforcement, courts, and corrections. Criminal law. The branch of modern law that concerns itself with offenses committed against society, its members, their property, and the social order. Criminal negligence. Behavior in which a person fails to reasonably perceive substantial and unjustifiable risks of dangerous consequences. Criminology. The scientific study of the causes and prevention of crime and the rehabilitation and punishment of offenders. Cyberstalking. The use of the internet, email, and other electronic communication technologies to stalk another person. Cyberterrorism. A form of terrorism that makes use of high technology, especially computers and the internet, in the planning and carrying out of terrorist attacks. Danger law. A law intended to prevent the pretrial release of criminal defendants judged to represent a danger to others in the community. Dark figure of crime. Crime that is not reported to the police and that remains unknown to officials. Date rape. Unlawful forced sexual intercourse with a female against her will that occurs within the context of a dating relationship. Date rape, or acquaintance rape, is a subcategory of rape that is of special concern today. Deadly force. Force likely to cause death or great bodily harm. Also, the intentional use of a firearm or other instrument resulting in a high probability of death. Defense, to a criminal charge. Evidence and arguments offered by a defendant and his or her attorney to show why the defendant should not be held liable for a criminal charge. Defense counsel. A licensed trial lawyer, hired or appointed to conduct the legal defense of a person accused of a crime and to represent him or her before a court of law. Deliberate indifference. A wanton disregard by corrections personnel for the well-being of inmates. Deliberate indifference requires both actual knowledge that a harm is occurring and disregard of the risk of harm. A prison official may be held liable under the Eighth Amendment for acting with deliberate indifference to inmate health or safety only if he or she knows that inmates face a substantial risk of serious harm and disregards that risk by failing to take reasonable measures to abate it. Delinquency. In the broadest usage, juvenile actions or conduct in violation of criminal law, juvenile status offenses, and other juvenile misbehavior. Delinquent child. A child who has engaged in activity that would be considered a crime if the child were an adult. The term delinquent is used to avoid the stigma associated with the term criminal. Dependent child. A child who has no parents or whose parents are unable to care for him or her. Design capacity. The number of inmates a prison was intended to hold when it was built or modified. Determinate sentencing. A model of criminal punishment in which an offender is given a fixed term that may be reduced by good time or gain time. Under the model, for example, all offenders convicted of the same degree of burglary would be sentenced to the same length of time behind bars. Deterrence. A goal of criminal sentencing that seeks to inhibit criminal behavior through the fear of punishment. Digital criminal forensics. The lawful seizure, acquisition, analysis, reporting, and safeguarding of data from digital devices that may contain information of evidentiary value to the trier of fact in criminal events. Diminished capacity. A defense based on claims of a mental condition that may be insufficient to exonerate the defendant of guilt but that may be relevant to specific mental elements of certain crimes or degrees of crime. Direct evidence. Evidence that, if believed, directly proves a fact. Eyewitness testimony and videotape documentation account for the majority of all direct evidence heard in the criminal courtroom. Direct supervision jail. A temporary confinement facility that eliminates many of the traditional barriers between inmates and correctional staff. Physical barriers in direct supervision jails are far less common than in traditional jails, allowing staff members the opportunity for greater interaction with, and control over, residents. Directed patrol. A police management strategy designed to increase the productivity of patrol officers through the scientific analysis and evaluation of patrol techniques. Discretionary release. The release of an inmate from prison to supervision that is decided by a parole board or other authority. Dispositional hearing. The final stage in the processing of adjudicated juveniles in which a decision is made on the form of treatment or penalty that should be imposed on the child. Dispute Resolution Center. An informal hearing place designed to mediate interpersonal disputes without resorting to the more formal arrangements of a criminal trial court. Diversion. The official suspension of criminal proceedings against an alleged offender at any point before the entering of a judgment and the referral of that person to a treatment or care program administered by a non-justice or private agency. Domestic terrorism. The unlawful use of force or violence by a group or an individual who is based and operates entirely within the United States and its territories without foreign direction and whose acts are directed at elements of the U.S. government or population. Double jeopardy. A common law and constitutional prohibition against a second trial for the same offense. Due process. A right guaranteed by the 5th, 6th, and 14th Amendments of the U.S. Constitution and generally understood, in legal contexts, to mean the due course of legal proceedings according to the rules and forms established for the protection of individual rights. In criminal proceedings, due process of law is generally understood to include the following basic elements: a law creating and defining the offense, an impartial tribunal having jurisdictional authority over the case, accusation in proper form, notice and opportunity to defend, trial according to established procedure, and discharge from all restraints or obligations unless convicted. Due process model. A criminal justice perspective that emphasizes individual rights at all stages of justice system processing. E. Electronic Communications Privacy Act, ECPA. A law passed by Congress in 1986 establishing the due process requirements that law enforcement officers must meet in order to legally intercept wire communications. Electronic evidence. Information and data of investigative value that are stored in or transmitted by an electronic device. Element of a crime. In a specific crime, one of the essential features of that crime, as specified by law or statute. Emergency search. A search conducted by the police without a warrant, which is justified on the basis of some immediate and overriding need, such as public safety, the likely escape of a dangerous suspect, or the removal or destruction of evidence. Entrapment. An improper or illegal inducement to crime by agents of law enforcement. Also, a defense that may be raised when such inducements have occurred. Equity. A sentencing principle, based on concerns with social equality, that holds that similar crimes should be punished with the same degree of severity, regardless of the social or personal characteristics of the offenders. Espionage. The gathering, transmitting, or losing of information related to the national defense in such a manner that the information becomes available to enemies of the United States and may be used to their advantage. Evidence. Anything useful to a judge or jury in deciding the facts of a case. Evidence may take the form of witness testimony, written documents, videotapes, magnetic media, photographs, physical objects, and so on. Evidence-based policing. The use of best available research on the outcomes of police work to implement guidelines and evaluate agencies, units, and officers. Ex post facto. Latin for after the fact. The Constitution prohibits the enactment of ex post facto laws, which make acts committed before the laws in question were passed punishable as crimes. Excessive force. The application of an amount or frequency of force greater than that required to compel compliance from a willing or unwilling subject. Exclusionary rule. The understanding, based on U.S. Supreme Court precedent, that incriminating information must be seized according to constitutional specifications of due process or it will not be allowed as evidence in a criminal trial. Exculpatory evidence. Information having a tendency to clear a person of guilt or blame. Excuse. A legal defense in which the defendant claims that some personal condition or circumstance at the time of the act was such that he or she should not be held accountable under the criminal law. Exemplary Projects Program. An initiative, sponsored by the Law Enforcement Assistance Administration, designed to recognize outstanding innovative efforts to combat crime and to provide assistance to crime victims. Expert witness. A person who has special knowledge and skills recognized by the court as relevant to the determination of guilt or innocence. Unlike lay witnesses, expert witnesses may express opinions or draw conclusions in their testimony. Federal court system. The three-tiered structure of federal courts, comprising U.S. District Courts, U.S. Courts of Appeals, and the U.S. Supreme Court. Felony. A criminal offense punishable by death or by incarceration in a prison facility for at least 1 year. First appearance. An appearance before a magistrate during which the legality of the defendant's arrest is initially assessed and the defendant is informed of the charges on which he or she is being held. At this stage in the criminal justice process, bail may be set or pretrial release arranged. Also called initial appearance. Fleeting targets exception. An exception to the exclusionary rule that permits law enforcement officers to search a motor vehicle based on probable cause but without a warrant. The fleeting targets exception is predicated on the fact that vehicles can quickly leave the jurisdiction of a law enforcement agency. Forcible rape, UCR. The carnal knowledge of a female forcibly and against her will. For statistical reporting purposes, the FBI defines forcible rape as unlawful sexual intercourse with a female, by force and against her will, or without legal or factual consent. Statutory rape differs from forcible rape in that it generally involves non-forcible sexual intercourse with a minor. Fruit of the poisonous tree doctrine. A legal principle that excludes from introduction at trial any evidence later developed as a result of an illegal search or seizure. G. Gain time. The amount of time deducted from time to be served in prison on a given sentence as a consequence of participation in special projects or programs. General deterrence. A goal of criminal sentencing that seeks to prevent others from committing crimes similar to the one for which a particular offender is being sentenced by making an example of the person sentenced. Good faith exception. An exception to the exclusionary rule. Law enforcement officers who conduct a search or who seize evidence on the basis of good faith, that is, when they believe they are operating according to the dictates of the law, and who later discover that a mistake was made, perhaps in the format of the application for a search warrant, may still use the seized evidence in court. Good time. The amount of time deducted from time to be served in prison on a given sentence as a consequence of good behavior. Grand jury. A group of jurors who have been selected according to law and have been sworn to hear the evidence and to determine whether there is sufficient evidence to bring the accused person to trial, to investigate criminal activity generally, or to investigate the conduct of a public agency or official. Grievance procedure. A formalized arrangement, usually involving a neutral hearing board, whereby institutionalized individuals have the opportunity to register complaints about the conditions of their confinement. Guilty but mentally ill, GBMI. A verdict, equivalent to a finding of guilty, that establishes that the defendant, although mentally ill, was in sufficient possession of his or her faculties to be morally blameworthy for his or her acts. H. Hands-off doctrine. A policy of non-intervention with regard to prison management that U.S. courts tended to follow until the late 1960s. For the past 30 years, the doctrine has languished as judicial intervention in prison administration dramatically increased, although there is now some evidence that a new hands-off era is approaching. Hate crime. A criminal offense in which the motive is hatred, bias, or prejudice, based on the actual or perceived race, color, religion, national origin, ethnicity, gender, or sexual orientation of another individual or group of individuals. Also called bias crime. Hearsay. Something that is not based on the personal knowledge of a witness. Witnesses who testify about something they have heard, for example, are offering hearsay by repeating information about a matter of which they have no direct knowledge. Hearsay rule. The long-standing precedent that hearsay cannot be used in American courtrooms. Rather than accepting testimony based on hearsay, the court will ask that the person who was the original source of the hearsay information be brought in to be questioned and cross-examined. Exceptions to the hearsay rule may occur when the person with direct knowledge is dead or is otherwise unable to testify. Home confinement. House arrest. Individuals ordered confined to their homes are sometimes monitored electronically to ensure they do not leave during the hours of confinement. Absence from the home during working hours is often permitted. Hudud crime. A serious violation of Islamic law that is regarded as an offense against God. I. Identity theft. A crime in which an impostor obtains key pieces of information, such as social security and driver's license numbers, to obtain credit, merchandise, and services in the name of the victim. The victim is often left with a ruined credit history and the time-consuming and complicated task of repairing the financial damages. Illegally seized evidence. Evidence seized without regard to the principles of due process as described by the Bill of Rights. Most illegally seized evidence is the result of police searches conducted without a proper warrant or of improperly conducted interrogations. Incapacitation. The use of imprisonment or other means to reduce the likelihood that an offender will commit future offenses. Inchoate offense. An offense not yet completed. Also, an offense that consists of an action or conduct that is a step toward the intended commission of another offense. Incompetent to stand trial. In criminal proceedings, a finding by a court that as a result of mental illness, defect, or disability, a defendant is incapable of understanding the nature of the charges and proceedings against him or her, of consulting with an attorney, and of aiding in his or her own defense. Indeterminate sentencing. A model of criminal punishment that encourages rehabilitation through the use of general and relatively unspecific sentences, such as a term of imprisonment of from 1 to 10 years. Indictment. A formal, written accusation submitted to a court by a grand jury, alleging that a specified person has committed a specified offense, usually a felony. Individual rights. The rights guaranteed to all members of American society by the U.S. Constitution, especially those found in the first 10 amendments to the Constitution, known as the Bill of Rights. These rights are particularly important to criminal defendants facing formal processing by the criminal justice system. Individual rights advocate. One who seeks to protect personal freedoms within the process of criminal justice. Information. A formal, written accusation submitted to a court by a prosecutor, alleging that a specified person has committed a specified offense. Infraction. A minor violation of state statute or local ordinance punishable by a fine or other penalty or by a specified, usually limited, term of incarceration. Inherent coercion. The tactics used by police interviewers that fall short of physical abuse but that nonetheless pressure suspects to divulge information. Insanity defense. A legal defense based on claims of mental illness or mental incapacity. Intake. The first step in decision-making regarding a juvenile whose behavior or alleged behavior is in violation of the law or could otherwise cause a juvenile court to assume jurisdiction. Intelligence-led policing. The collection and analysis of information to produce an intelligence end product designed to inform police decision-making at both the tactical and strategic levels. Intensive probation supervision, IPS. A form of probation supervision involving frequent face-to-face contact between the probationer and the probation officer. Intermediate sanctions. The use of split sentencing, shock probation or parole, shock incarceration, community service, intensive supervision, or home confinement in lieu of other, more traditional sanctions, such as imprisonment and fines. Internal affairs. The branch of a police organization tasked with investigating charges of wrongdoing involving members of the department. International terrorism. The unlawful use of force or violence by a group or an individual who has some connection to a foreign power or whose activities transcend national boundaries against people or property in order to intimidate or coerce a government, the civilian population, or any segment thereof in furtherance of political or social objectives. Interrogation. The information-gathering activity of police officers that involves the direct questioning of suspects. Islamic law. A system of laws, operative in some Arab countries, based on the Muslim religion and especially the Holy Book of Islam, the Quran. Jail. A confinement facility administered by an agency of local government, typically a law enforcement agency, intended for adults but sometimes also containing juveniles, which holds people detained pending adjudication or committed after adjudication, usually those sentenced to a year or less. Judge. An elected or appointed public official who presides over a court of law and who is authorized to hear and sometimes to decide cases and to conduct trials. Judicial review. The power of a court to review actions and decisions made by other agencies of government. Jurisdiction. The territory, subject matter, or people over which a court or other justice agency may exercise lawful authority, as determined by statute or constitution. Jurisprudence. The philosophy of law. Also, the science and study of the law. Juror. A member of a trial or grand jury who has been selected for jury duty and is required to serve as an arbiter of the facts in a court of law. Jurors are expected to render verdicts of guilty or not guilty as to the charges brought against the accused, although they may sometimes fail to do so, as in the case of a hung jury. Jury selection. The process whereby, according to law and precedent, members of a particular trial jury are chosen. Just deserts. A model of criminal sentencing that holds that criminal offenders deserve the punishment they receive at the hands of the law and that punishments should be appropriate to the type and severity of the crime committed. Justice. The principle of fairness, the ideal of moral equity. Justice model. A contemporary model of imprisonment based on the principle of just deserts. Justification. A legal defense in which the defendant admits to committing the act in question but claims it was necessary in order to avoid some greater evil. Juvenile. A youth at or below the upper age of juvenile court jurisdiction in a particular state. Juvenile court. Any court that has jurisdiction over matters involving juveniles. Juvenile disposition. The decision of a juvenile court, concluding a dispositional hearing, that an adjudicated juvenile be committed to a juvenile correctional facility, be placed in a juvenile residence, shelter, or care or treatment program, be required to meet certain standards of conduct, or be released. Juvenile justice system. Government agencies that function to investigate, supervise, adjudicate, care for, or confine youthful offenders and other children subject to the jurisdiction of the juvenile court. Juvenile petition. A document filed in juvenile court alleging that a juvenile is a delinquent, a status offender, or a dependent and asking that the court assume jurisdiction over the juvenile or that an alleged delinquent be transferred to a criminal court for prosecution as an adult. Kansas City experiment. The first large-scale scientific study of law enforcement practices. Sponsored by the Police Foundation, it focused on the practice of preventive patrol. Knapp Commission. A committee that investigated police corruption in New York City in the early 1970s. Landmark case. A precedent-setting court decision that produces substantial changes in both the understanding of the requirements of due process and in the practical day-to-day operations of the justice system. Larceny theft, UCR. The unlawful taking or attempted taking, carrying, leading, or riding away of property from the possession or constructive possession of another. Motor vehicles are excluded. Larceny is the most common of the 8 major offenses, although probably only a small percentage of all larcenies are actually reported to the police because of the small dollar amounts involved. Latent evidence. Evidence of relevance to a criminal investigation that is not readily seen by the unaided eye. Law. A rule of conduct, generally found enacted in the form of a statute, that proscribes or mandates certain forms of behavior. Statutory law is often the result of moral enterprise by interest groups that, through the exercise of political power, are successful in seeing their valued perspectives enacted into law. Law Enforcement Assistance Administration, LEAA. A now-defunct federal agency established under Title I of the Omnibus Crime Control and Safe Streets Act of 1968 to funnel federal funding to state and local law enforcement agencies. Lay witness. An eyewitness, character witness, or other person called on to testify who is not considered an expert. Lay witnesses must testify to facts only and may not draw conclusions or express opinions. Legal cause. A legally recognizable cause. A legal cause must be demonstrated in court in order to hold an individual criminally liable for causing harm. Legalistic style. A style of policing marked by a strict concern with enforcing the precise letter of the law. Legalistic departments may take a hands-off approach to disruptive or problematic behavior that does not violate the criminal law. Lethal weapon. A weapon that is designed to disable, capture, or immobilize, but not kill, a suspect. Occasional deaths do result from the use of such weapons, however. Line operations. In police organizations, the field activities or supervisory activities directly related to day-to-day police work. Malware. Malicious computer programs such as viruses, worms, and Trojan horses. Mandatory release. The release of an inmate from prison that is determined by statute or sentencing guidelines and is not decided by a parole board or other authority. Mandatory sentencing. A structured sentencing scheme that allows no leeway in the nature of the sentence required and under which clearly enumerated punishments are mandated for specific offenses or for habitual offenders convicted of a series of crimes. Mens rea. The state of mind that accompanies a criminal act. Also, a guilty mind. Miranda triggers. The dual principles of custody and interrogation, both of which are necessary before an advisement of rights is required. Miranda warnings. The advisement of rights due criminal suspects by the police before questioning begins. Miranda warnings were first set forth by the U.S. Supreme Court in the 1966 case of Miranda v. Arizona. Misdemeanor. An offense punishable by incarceration, usually in a local confinement facility, for a period whose upper limit is prescribed by statute in a given jurisdiction, typically 1 year or less. Mitigating circumstances. Circumstances relating to the commission of a crime that may be considered to reduce the blameworthiness of the defendant. Mixed sentence. A sentence that requires that a convicted offender serve weekends, or other specified periods of time, in a confinement facility, usually a jail, while undergoing probationary supervision in the community. M'Naughton rule. A rule for determining insanity that asks whether the defendant knew what he or she was doing or whether the defendant knew that what he or she was doing was wrong. Motive. A person's reason for committing a crime. Motor vehicle theft, UCR. The theft or attempted theft of a motor vehicle. Motor vehicle is defined as a self-propelled road vehicle that runs on land surface and not on rails. The stealing of trains, planes, boats, construction equipment, and most farm machinery is classified as larceny under the UCR program, not as motor vehicle theft. Multiculturalism. The existence within one society of diverse groups that maintain unique cultural identities while frequently accepting and participating in the larger society's legal and political systems. Multiculturalism is often used in conjunction with the term diversity to identify many distinctions of social significance. Murder. The unlawful killing of a human being. Murder is a generic term that in common usage may include first and second degree murder, manslaughter, involuntary manslaughter, and other similar offenses. N. National Crime Victimization Survey, NCVS. An annual survey of selected American households conducted by the Bureau of Justice Statistics to determine the extent of criminal victimization, especially unreported victimization, in the United States. National Incident-Based Reporting System, NIBRS. An incident-based reporting system that collects data on every single crime occurrence. NIBRS data will soon supersede the kinds of traditional data provided by the FBI's Uniform Crime Reports. Neglected child. A child who is not receiving the proper level of physical or psychological care from his or her parents or guardians or who has been placed up for adoption in violation of the law. NLETS. The International Justice and Public Safety Information Sharing Network. Nolo contendere. A plea of no contest. A no contest plea is used when the defendant does not wish to contest conviction. Because the plea does not admit guilt, however, it cannot provide the basis for later civil suits that might follow a criminal conviction. A. Offense. A violation of the criminal law. Also, in some jurisdictions, a minor crime, such as jaywalking, that is sometimes described as ticketable. Opening statement. The initial statement of the prosecution or the defense, made in a court of law to a judge, or to a judge and jury, describing the facts that he or she intends to present during trial to prove the case. Operational capacity. The number of inmates a prison can effectively accommodate based on management considerations. Organized crime. The unlawful activities of the members of a highly organized, disciplined association engaged primarily in supplying illegal goods and services, including gambling, prostitution, loan sharking, narcotics, and labor racketeering. Original jurisdiction. The lawful authority of a court to hear or to act on a case from its beginning and to pass judgment on the law and the facts. The authority may be over a specific geographic area or over particular types of cases. p. Parens patriae. A common law principle that allows the state to assume a parental role and to take custody of a child when he or she becomes delinquent, is abandoned, or is in need of care that the natural parents are unable or unwilling to provide. Parole. The status of a convicted offender who has been conditionally released from prison by a paroling authority before the expiration of his or her sentence, is placed under the supervision of a parole agency, and is required to observe the conditions of parole. Parole Board. A state paroling authority. Most states have parole boards that decide when an incarcerated offender is ready for conditional release. Some boards also function as revocation hearing panels. Parole revocation. The administrative action of a paroling authority removing a person from parole status in response to a violation of lawfully required conditions of parole, including the prohibition against committing a new offense, and usually resulting in a return to prison. Parole, probation, violation. An act or a failure to act by a parolee, or probationer, that does not conform to the conditions of his or her parole, or probation. Part I offenses. A set of UCR categories used to report murder, forcible rape, robbery, aggravated assault, burglary, larceny theft, motor vehicle theft, and arson, as defined under the FBI's Uniform Crime Reporting Program. Also called major crimes. Part 2 offenses. A set of UCR categories used to report arrests for less serious offenses. Peace Officer Standards and Training, POST, Program. The official program of a state or legislative jurisdiction that sets standards for the training of law enforcement officers. All states set such standards, although not all use the term POST. Penal Code. The written, organized, and compiled form of the criminal laws of a jurisdiction. Peremptory challenge. The right to challenge a potential juror without disclosing the reason for the challenge. Prosecutors and defense attorneys routinely use peremptory challenges to eliminate from juries individuals who, although they express no obvious bias, are thought to be capable of swaying the jury in an undesirable direction. Perjury. The intentional making of a false statement as part of the testimony by a sworn witness in a judicial proceeding on a matter relevant to the case at hand. Plain view. A legal term describing the ready visibility of objects that might be seized as evidence during a search by police in the absence of a search warrant specifying the seizure of those objects. To lawfully seize evidence in plain view, officers must have a legal right to be in the viewing area and must have cause to believe that the evidence is somehow associated with criminal activity. Plea. In criminal proceedings, the defendant's formal answer in court to the charge contained in a complaint, information, or indictment that he or she is guilty of the offense charged, is not guilty of the offense charged, or does not contest the charge. Plea bargaining. The process of negotiating an agreement among the defendant, the prosecutor, and the court as to an appropriate plea and associated sentence in a given case. Plea bargaining circumvents the trial process and dramatically reduces the time required for the resolution of a criminal case. Police-community relations, PCR. An area of police activity that recognizes the need for the community and the police to work together effectively and that is based on the notion that the police derive their legitimacy from the community they serve. Many police agencies began to explore PCR in the 1960s and 1970s. Police corruption. The abuse of police authority for personal or organizational gain. Police discretion. The opportunity of law enforcement officers to exercise choice in their daily activities. Police ethics. The special responsibility to adhere to moral duty and obligation that is inherent in police work. Police management. The administrative activities of controlling, directing, and coordinating police personnel, resources, and activities in the service of crime prevention, the apprehension of criminals, the recovery of stolen property, and the performance of a variety of regulatory and helping services. Police professionalism. The increasing formalization of police work and the accompanying rise in public acceptance of the police. Police subculture. a particular set of values, beliefs, and acceptable forms of behavior characteristic of American police with which the police profession strives to imbue new recruits. Socialization into the police subculture commences with recruit training and continues thereafter. Police subculture. The set of informal values that characterize the police force as a distinct community with a common identity. Police use of force. The use of physical restraint by a police officer when dealing with a member of the public. Police working personality. All aspects of the traditional values and patterns of behavior evidenced by police officers who have been effectively socialized into the police subculture. Characteristics of the police personality often extend to the personal lives of law enforcement personnel. Precedent. A legal principle that ensures that previous judicial decisions are authoritatively considered and incorporated into future cases. Preliminary hearing. A proceeding before a judicial officer in which three matters must be decided: whether a crime was committed, whether the crime occurred within the territorial jurisdiction of the court, and whether there are reasonable grounds to believe that the defendant committed the crime. Pre-sentence investigation. The examination of a convicted offender's background before sentencing. Pre-sentence examinations are generally conducted by probation or parole officers and are submitted to sentencing authorities. Presumptive sentencing. A model of criminal punishment that meets the following conditions: the appropriate sentence for an offender convicted of a specific charge is presumed to fall within a range of sentences authorized by sentencing guidelines that are adopted by a legislatively created sentencing body, usually a sentencing commission. Sentencing judges are expected to sentence within the range or to provide written justification for departure. A mechanism is in place for review, usually appellate, of any departure from the guidelines. Pretrial release. The release of an accused person from custody, for all or part of the time before or during prosecution, upon his or her promise to appear in court when required. Prison. A state or federal confinement facility that has custodial authority over adults sentenced to confinement. Prison argot. The slang characteristic of prison subculture and prison life. Prison capacity. The size of the correctional population an institution can effectively hold. There are three types of prison capacity: rated, operational, and design. Prison subculture. The values and behavioral patterns characteristic of prison inmates. Prison subculture has been found to be surprisingly consistent across the country. Prisonization. The process whereby newly institutionalized offenders come to accept prison lifestyles and criminal values. Although many inmates begin their prison experience with only a few values that support criminal behavior, the socialization experience they undergo while incarcerated leads to a much wider acceptance of such values. Private prison. A correctional institution operated by a private firm on behalf of a local or state government. Private protective services. Independent or proprietary commercial organizations that provide protective services to employers on a contractual basis. Privatization. The movement toward the wider use of private prisons. Probable cause. A set of facts and circumstances that would induce a reasonably intelligent and prudent person to believe that a particular other person has committed a specific crime. Also, reasonable grounds to make or believe an accusation. Probable cause refers to the necessary level of belief that would allow for police seizures, arrests, of individuals and full searches of dwellings, vehicles, and possessions. Probation. A sentence of imprisonment that is suspended. Also, the conditional freedom granted by a judicial officer to a convicted offender, as long as the person meets certain conditions of behavior. Probation revocation. A court order taking away a convicted offender's probationary status and usually withdrawing the conditional freedom associated with that status in response to a violation of the conditions of probation. Probative value. The degree to which a particular item of evidence is useful in, and relevant to, proving something important in a trial. Problem police officer. A law enforcement officer who exhibits problem behavior, as indicated by high rates of citizen complaints and use of force incidents and by other evidence. Problem-solving policing. A type of policing that assumes that many crimes are caused by existing social conditions within the community and that crimes can be controlled by uncovering and effectively addressing underlying social problems. Problem-solving policing makes use of community resources, such as counseling centers, welfare programs, and job training facilities. It also attempts to involve citizens in crime prevention through education, negotiation, and conflict management. Procedural defense. A defense that claims that the defendant was in some significant way discriminated against in the justice process or that some important aspect of official procedure was not properly followed in the investigation or prosecution of the crime charged. Procedural law. The part of the law that specifies the methods to be used for enforcing substantive law. Property bond. The setting of bail in the form of land, houses, stocks, or other tangible property. In the event that the defendant absconds before trial, the bond becomes the property of the court. Property crime. A UCR offense category that includes burglary, larceny theft, motor vehicle theft, and arson. Proportionality. A sentencing principle that holds that the severity of sanctions should bear a direct relationship to the seriousness of the crime committed. Prosecutor. An attorney whose official duty is to conduct criminal proceedings on behalf of the state or the people against those accused of having committed criminal offenses. Prosecutorial discretion. The decision-making power of prosecutors, based on the wide range of choices available to them, in the handling of criminal defendants, the scheduling of cases for trial, the acceptance of negotiated pleas, and so on. The most important form of prosecutorial discretion lies in the power to charge, or not to charge, a person with an offense. Psychological manipulation. Manipulative actions by police interviewers, designed to pressure suspects to divulge information, that are based on subtle forms of intimidation and control. Public defender. An attorney employed by a government agency or subagency, or by a private organization under contract to a government body, for the purpose of providing defense services to indigents, or an attorney who has volunteered such service. Public order advocate. One who believes that under certain circumstances involving a criminal threat to public safety, the interests of society should take precedence over individual rights. Q. Quality of life offense. A minor violation of the law, sometimes called a petty crime, that demoralizes community residents and businesspeople. Quality of life offenses involve acts that create physical disorder, for example, excessive noise or vandalism, or that reflect social decay, for example, panhandling and prostitution. R. Racial profiling. Any police-initiated action that relies on the race, ethnicity, or national origin rather than the behavior of an individual, or on information that leads the police to a particular individual who has been identified as being, or having been, engaged in criminal activity. Rape. Unlawful sexual intercourse, achieved through force and without consent. Broadly speaking, the term rape has been applied to a wide variety of sexual attacks and may include same-sex rape and the rape of a male by a female. Some jurisdictions refer to same-sex rape as sexual battery. Rated capacity. The number of inmates a prison can handle according to the judgment of experts. Reasonable force. The degree of force that is appropriate in a given situation and is not excessive. Also, the minimum degree of force necessary to protect oneself, one's property, a third party, or the property of another in the face of a substantial threat. Reasonable suspicion. The level of suspicion that would justify an officer in making further inquiry or in conducting further investigation. Reasonable suspicion may permit stopping a person for questioning or for a simple pat-down search. Also, a belief, based on a consideration of the facts at hand and on reasonable inferences drawn from those facts, that would induce an ordinarily prudent and cautious person under the same circumstances to conclude that criminal activity is taking place or that criminal activity has recently occurred. Reasonable suspicion is a general and reasonable belief that a crime is in progress or has occurred, whereas probable cause is a reasonable belief that a particular person has committed a specific crime. Recidivism. The repetition of criminal behavior. In statistical practice, a recidivism rate may be any of a number of possible counts or instances of arrest, conviction, correctional commitment, or correctional status change related to repetitions of these events within a given period of time. Reckless behavior. Activity that increases the risk of harm. Regional jail. A jail that is built and run using the combined resources of a variety of local jurisdictions. Rehabilitation. The attempt to reform a criminal offender. Also, the state in which a reformed offender is said to be. Release on recognizance, ROR. The pretrial release of a criminal defendant on his or her written promise to appear in court as required. No cash or property bond is required. Remote location monitoring. A supervision strategy that uses electronic technology to track offenders sentenced to house arrest or those who have been ordered to limit their movements while completing a sentence involving probation or parole. Restitution. A court requirement that an alleged or convicted offender pay money or provide services to the victim of the crime or provide services to the community. Restoration. A goal of criminal sentencing that attempts to make the victim whole again. Restorative justice. A sentencing model that builds on restitution and community participation in an attempt to make the victim whole again. Retribution. The act of taking revenge on a criminal perpetrator. Revocation hearing. A hearing held before a legally constituted hearing body, such as a parole board, to determine whether a parolee or probationer has violated the conditions and requirements of his or her parole or probation. Robbery, UCR. The unlawful taking or attempted taking of property that is in the immediate possession of another by force or violence and or by putting the victim in fear. Armed robbery differs from unarmed, or strong-arm, robbery with regard to the presence of a weapon. Contrary to popular conceptions, highway robbery does not necessarily occur on a street, and rarely in a vehicle. The term highway robbery applies to any form of robbery that occurs outdoors in a public place. Rule of law. The maxim that an orderly society must be governed by established principles and known codes that are applied uniformly and fairly to all of its members. Rules of evidence. Court rules that govern the admissibility of evidence at criminal hearings and trials. Scientific jury selection. The use of correlational techniques from the social sciences to gauge the likelihood that potential jurors will vote for conviction or for acquittal. Scientific police management. The application of social science techniques to the study of police administration for the purpose of increasing effectiveness, reducing the frequency of citizen complaints, and enhancing the efficient use of available resources. Search incident to an arrest. A warrantless search of an arrested individual conducted to ensure the safety of the arresting officer. Because individuals placed under arrest may be in possession of weapons, courts have recognized the need for arresting officers to protect themselves by conducting an immediate search of arrestees without obtaining a warrant. Security Threat Group, STG. An inmate group, gang, or organization whose members act together to pose a threat to the safety of corrections staff or the public, or who prey on other inmates, or who threaten the secure and orderly operation of a correctional institution. Self-defense. The protection of oneself or of one's property from unlawful injury or from the immediate risk of unlawful injury. Also, the justification that the person who committed an act that would otherwise constitute an offense reasonably believed that the act was necessary to protect self or property from immediate danger. Sentencing. The imposition of a criminal sanction by a judicial authority. Sequestered jury. A jury that is isolated from the public during the course of a trial and throughout the deliberation process. Service style. A style of policing marked by a concern with helping rather than strict enforcement. Service-oriented police agencies are more likely to take advantage of community resources, such as drug treatment programs, than are other types of agencies. Sexual battery. Intentional and wrongful physical contact with a person, without his or her consent, that entails a sexual component or purpose. Sheriff. The elected chief officer of a county law enforcement agency. The sheriff is usually responsible for law enforcement in unincorporated areas and for the operation of the county jail. Shock incarceration. A sentencing option that makes use of boot camp type prisons to impress on convicted offenders the realities of prison life. Shock probation. The practice of sentencing offenders to prison, allowing them to apply for probationary release, and enacting such release in surprise fashion. Offenders who receive shock probation may not be aware that they will be released on probation and may expect to spend a much longer time behind bars. Sneak and peek search. A search that occurs in the suspect's absence and without his or her prior knowledge. Also known as a delayed notification search. Social control. The use of sanctions and rewards within a group to influence and shape the behavior of individual members of that group. Social control is a primary concern of social groups and communities, and it is their interest in the exercise of social control that leads to the creation of both criminal and civil statutes. Social debt. A sentencing principle that holds that an offender's criminal history should objectively be taken into account in sentencing decisions. Social justice. An ideal that embraces all aspects of civilized life and that is linked to fundamental notions of fairness and to cultural beliefs about right and wrong. Software piracy. The unauthorized duplication of software or the illegal transfer of data from one storage medium to another. Software piracy is one of the most prevalent computer crimes in the world. Spam. Unsolicited commercial bulk email, UCBE, whose primary purpose is the commercial advertisement or promotion of a commercial product or service. Span of control. The number of police personnel or the number of units supervised by a particular officer. Specific deterrence. A goal of criminal sentencing that seeks to prevent a particular offender from engaging in repeat criminality. Speedy Trial Act. A 1974 federal law requiring that proceedings against a defendant in a criminal case begin within a specified period of time, such as 70 working days after indictment. Some states also have speedy trial requirements. Split sentence. A sentence explicitly requiring the convicted offender to serve a period of confinement in a local, state, or federal facility, followed by a period of probation. Staff operations. In police organizations, activities, such as administration and training, that provide support for line operations. Stalking. Repeated harassing and threatening behavior by one individual against another, aspects of which may be planned or carried out in secret. Stalking might involve following a person, appearing at a person's home or place of business, making harassing phone calls, leaving written messages or objects, or vandalizing a person's property. Most stalking laws require that the perpetrator make a credible threat of violence against the victim or members of the victim's immediate family. Stare decisis. A legal principle that requires that in subsequent cases on similar issues of law and fact, courts be bound by their own earlier decisions and by those of higher courts having jurisdiction over them. The term literally means standing by decided matters. State Court Administrator. A coordinator who assists with case flow management, operating funds budgeting, and court docket administration. State Court System. A state judicial structure. Most states have at least 3 court levels, generally, trial courts, appellate courts, and a state Supreme Court. Status offender. A child who commits an act that is contrary to the law by virtue of the offender's status as a child. Purchasing cigarettes, buying alcohol, and being truant are examples of such behavior. Status offense. An act or conduct that is declared by statute to be an offense, but only when committed by or engaged in by a juvenile, and that can be adjudicated only by a juvenile court. Statutory law. Written or codified law, the law on the books, as enacted by a government body or agency having the power to make laws. Strategic policing. A type of policing that retains the traditional police goal of professional crime fighting but enlarges the enforcement target to include non-traditional kinds of criminals, such as serial offenders, gangs and criminal associations, drug distribution networks, and sophisticated white-collar and computer criminals. Strategic policing generally makes use of innovative enforcement techniques, including intelligence operations, undercover stings, electronic surveillance, and sophisticated forensic methods. Strict liability. Liability without fault or intention. Strict liability offenses do not require mens rea. Structured sentencing. A model of criminal punishment that includes determinate and commission-created presumptive sentencing schemes, as well as voluntary/advisory sentencing guidelines. Subpoena. A written order issued by a judicial officer or grand jury requiring an individual to appear in court and to give testimony or to bring material to be used as evidence. Some subpoenas mandate that books, papers, and other items be surrendered to the court. Substantive criminal law. The part of the law that defines crimes and specifies punishments. Suspicionless search. A search conducted by law enforcement personnel without a warrant and without suspicion. Suspicionless searches are permissible only if based on an overriding concern for public safety. Tazir crime. A minor violation of Islamic law that is regarded as an offense against society, not God. Team policing. The reorganization of conventional patrol strategies into an integrated and versatile police team assigned to a fixed district. Teen court. An alternative approach to juvenile justice in which alleged offenders are judged and/or sentenced by a jury of their peers. Terrorism. A violent act or an act dangerous to human life in violation of the criminal laws of the United States or of any state committed to intimidate or coerce a government, the civilian population, or any segment thereof in furtherance of political or social objectives. Testimony. Oral evidence offered by a sworn witness on the witness stand during a criminal trial. Tort. A wrongful act, damage, or injury not involving a breach of contract. Also, a private or civil wrong or injury. Total institution. An enclosed facility separated from society both socially and physically, where the inhabitants share all aspects of their daily lives. Transnational organized crime. Unlawful activity undertaken and supported by organized criminal groups operating across national boundaries. Treason. A U.S. citizen's actions to help a foreign government overthrow, make war against, or seriously injure the United States. Also, the attempt to overthrow the government of the society of which one is a member. Trial. In criminal proceedings, the examination in court of the issues of fact and relevant law in a case for the purpose of convicting or acquitting the defendant. Trial de novo. Literally, new trial. The term is applied to cases that are retried on appeal, as opposed to those that are simply reviewed on the record. Truth in sentencing. A close correspondence between the sentence imposed on an offender and the time actually served before release from prison. Undisciplined child. A child who is beyond parental control, as evidenced by his or her refusal to obey legitimate authorities, such as school officials and teachers. Uniform Crime Reports, UCR. An annual FBI publication that summarizes the incidence and rate of reported crimes throughout the United States. USA Patriot Act. A federal law, Public Law 107-56, enacted in response to terrorist attacks on the World Trade Center and the Pentagon on September 11, 2001. The law, officially titled the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act, substantially broadened the investigative authority of law enforcement agencies throughout America and is applicable to many crimes other than terrorism. Verdict. The decision of the jury in a jury trial or of a judicial officer in a non-jury trial. Victim Assistance Program. An organized program that offers services to victims of crime in the areas of crisis intervention and follow-up counseling and that helps victims secure their rights under the law. Victim Impact Statement. The in-court use of victim or survivor-supplied information by sentencing authorities seeking to make an informed sentencing decision. Violent crime. A UCR offense category that includes murder, forcible rape, robbery, and aggravated assault. Voluntary/advisory sentencing guidelines. Recommended sentencing policies that are not required by law. W. Warrant. In criminal proceedings, a writ issued by a judicial officer directing a law enforcement officer to perform a specified act and affording the officer protection from damages if he or she performs it. Watchman style. A style of policing marked by a concern for order maintenance. Watchman policing is characteristic of lower-class communities where informal police intervention into the lives of residents is employed in the service of keeping the peace. White-collar crime. Nonviolent crime for financial gain committed by means of deception by people whose occupational status is entrepreneurial, professional, or semi-professional and that utilizes their special occupational skills and opportunities. Also, nonviolent crime for financial gain utilizing deception and committed by means of deception by anyone who has special technical and professional knowledge of business and government, irrespective of the person's occupation. Writ of certiorari. A writ issued from an appellate court for the purpose of obtaining from a lower court the record of its proceedings in a particular case. In some states, this writ is the mechanism for discretionary review. A request for review is made by petitioning for a writ of certiorari, and the granting of review is indicated by the issuance of the writ. Writ of habeas corpus. A writ that directs the person detaining a prisoner to bring him or her before a judicial officer to determine the lawfulness of the imprisonment. X. Y. Z.